All right, I'm going to begin by introducing Julie Miller, who's going to begin this presentation on investigative strategies. Thank you, Julie.
Thank you, Davin. Hi, everyone. My name is Julie Miller. I'm one of the presenters today. I am the director of the Administrative Litigation Unit. I started at the Justice Center in December of 2013 as an attorney in the litigation unit. I left for a little while, went to OCFS as an ALJ. I came back here as an ALJ, and then I got promoted to this position. I've held this position for about 3 years now. So I am one of the presenters today talking about investigation strategies. What I'm going to cover, I'm going to go to the next slide, is our agenda for today. I'm going to cover the Justice Center legal mandate and review the 8 offenses. And then my colleagues are going to talk about the Justice Center strategy memo. Excuse me. So the Justice Center was enacted, I'm not sure if everyone knows this, but the Justice Center, ALJ, great question, administrative law judge. So I apologize. The Justice Center was enacted on June 30th, 2013. So we are coming up on our 12th year this year. And we created, the legislator created the Social Services Law, Article 11, and it's specifically for the Justice Center. What happens is, as you know, reports of abuse or neglect among the oversight agencies that we have come to us, and we handle those. We have 8 offenses that I'm going to talk about today. Anything outside of those 8 offenses that we're really going to focus on 4 today. Yeah, 4 today. But anything outside of that is not going to be within our purview or our jurisdiction of the Justice Center. All right, so as I mentioned, so it's under Social Services Law, Article 11. There are 8 offenses that are identified that we are required to investigate. They are neglect, physical abuse, psychological abuse, obstruction of reports of reportable incidents, deliberate inappropriate use of restraints, sexual abuse, use of aversive conditioning, and unlawful use or administration of a controlled substance. Next slide. Preponderance of the evidence is what is the standard that's applied for what we do in our investigations, as well as the administrative hearings. Section 493, Article 11 states that a finding shall be based upon a preponderance of the evidence. What does that mean? That's really the standard of proof. So when we're looking at they're asking questions about leaving the slide of the 8 offenses so I could jot them down. They're going to get this afterwards, right, Davin?
Right. All the slides will be sent to you. You do not need to take notes. Just sit back and listen, and this will be recorded as well.
Oh, thank you. So what does that mean? It's the standard of proof in these administrative proceedings. It means conduct that's more likely to have occurred. So when we're evaluating a case, we're saying, based upon everything that we've collected, is it more likely than not that this event occurred? Let me go to the next slide. So what's interesting is I mentioned that there's 8 types of offenses that we investigate, or we are, required by law to investigate and look into. So neglect, as you could see, is our biggest one. I would say the majority of our cases that I see come through here is neglect. Then physical abuse is our second largest category or offense, obstruction, and then psychological abuse. And then those other 4 that we briefly touched upon, which I'm not going to get into any detail today, but those are, because they're so small, it's only 2% of all of those combined. In 2024, just so you know some information, there was 14,260 allegations of abuse or neglect, and of those that were allegations, only 39% were substantiated. So when a report comes in, we investigate it. Could be the Justice Center, could be the state oversight agency. It is investigated, and some of those were unsubstantiated. I'm going to get into a little bit more detail about the 4 most common offenses. So we're going to talk about the elements of these offenses. Each one of the ones that I'm going to talk about, I'm going to start with neglect, but we're going to go through the elements of neglect. When we're looking at a neglect allegation, we have to make sure, because there's different elements that compose of this allegation, we have to look at, do I have a preponderance of the evidence for each one of these elements? So each component must be found to have more than likely to have occurred. Missing components, so if I don't have one of those things that I need for neglect, would result in an unsubstantiated allegation. So let's talk about neglect. For neglect, excuse me, I'm gonna turn this off. What we're looking for, the first thing is we have to make sure that the person is a custodian. Usually a custodian is defined as the DSP, someone who's working, someone who's actually caring for that individual. Then we look to see whether or not that custodian has a duty to that individual receiving services. The next element that we look at for neglect is, did that custodian breach or violate that duty to the person receiving services? It could be by action, failure to act, or they're just inattentive. And as a result, so this is the other part, we also have to show that it did result in or is likely to result in physical injury or serious or protracted impairment of the physical, mental, or emotional condition of an individual. What does that mean? That was a lot of words I just threw at everybody. So serious means significant, something that really affected them. Protracted means it occurred over a longer period of time. For example, if someone said, called someone a bad name, and the staff member did that to a person receiving services, and they're observed to be upset or distraught for days, that would be protracted, days and days and days, maybe even weeks. So that's what we're looking for that term. Mental or emotional condition. In order to establish that, I'm looking for like a psychological setback, lack of trust, depression. Are they crying? Are they withdrawn? Do they not want to participate in activities that they used to participate in? All of that's relevant. When you are considering an allegation of neglect, what we're looking for, critical evidence that we're looking for, is job descriptions, policies, practices, the practice at the facility. You're going to interview witnesses, the person receiving services, the subject of the report. If there are videos or photographs, you're going to try to obtain those. So the job description, policies, and practice at the facility is actually going to help establish that the custodian had a duty. When you interview the witnesses, the individual receiving services, the subject, you're going to see, did they breach that duty? You're also going to interview witnesses nearby at the time of the incident, medical professional in case there's a physical injury. And that's to establish, so if we have that breach, that fourth bullet there is going to establish that it caused what I told you, it could cause physical injury or the likelihood of the serious or protracted impairment. You're also going to interview other staff regarding their plans. So I had a case where the subject, fell asleep, and our individual was one-to-one. And that's why I put that in there, because why were they on one-to-one? In my situation, the individual was not harmed because the subject fell asleep. So I needed to know, well, why was he on one-to-one? What could have happened? He could have fallen out of the bed. He had a history of anxiety or anxiousness. So there could have been a mental or emotional likelihood of harm there. So that's why that's important. So why is that in place? Next element or offense we're going to talk about is physical abuse. This one, what's really interesting about physical abuse is what we really need to establish first. They're a custodian, we have to get that first, but really what we have to also show is that there's contact. So they actually have to have physical contact with the person receiving services, the subject with the person receiving services, for us to establish physical abuse. From that contact, the next element we're looking at is intentionally or recklessly caused one of the following, and it's similar to neglect: physical injury, or serious or protracted impairment of the physical, mental, or emotional condition of the individual, or the likelihood there are. There's a question in there. I'm just going to pause that for 1 second before I get to it. I can't
Go
hear
ahead,
that.
Julie. But I'll monitor them for you. And this seems to be a little specific, but go on.
Okay. Physical abuse, I really want to talk about, when we think of physical abuse, we often think about a physical injury. We don't only have to focus on physical injury in order to establish physical abuse. It also has in here that someone could have serious or protracted impairment of a mental or emotional condition, or the likelihood thereof. There's a case that came out. It's called Matter of Kelly. It's actually an appellate division case that came out where a staff member actually used an inappropriate language or term describing a person receiving services. Although it was a neglect allegation there, not physical abuse, what they said is, and I love this language, they said, these individuals, these staff members are paid to care for our people that are receiving services. They're in a position of trust, a position of authority to make physical contact with them. Maybe they don't get injured, but we could have the impairment or likelihood thereof of the emotional or mental condition because they're upset. That is someone they care for or someone they trust, and they hit them or slap them or punch them. So I don't want to only think about physical abuse only with a physical injury. There's also that other component. One other thing that we need to consider is without reasonable emergency. What we're talking about there, excuse me, let me go back. What we're talking about there is if there is an extreme situation going on, say an individual is about to run into a road and the staff member needs to like grab them to pull them back, that's an emergency. So if there's a little bit of an injury or bruising, that would not fall under this physical abuse offense. It really would fall under the emergency intervention exceptions, basically an exception to being able for a staff member actually touching them or contacting them or injuring them for that sole purpose. So what does intentional or reckless mean? Because that's one of the elements in physical abuse. So intentional means that you actually have a conscious objective to cause a result. So a great example, person receiving services is acting out and I want them to stop. I'm the staff member and I slap them. I wanted that to happen. I intended to slap them because I wanted them to do something. So I intended that. Reckless is you're aware of a substantial and unjustifiable risk and you consciously disregard such a risk. And I wrote driving on a sidewalk because in law school, one of my teachers said that. And I think that's a great idea. So you're on a road, you see people walking on the sidewalk, and you decide to drive, you're in your car and you decide to drive on the sidewalk. Maybe you didn't intend to hit the people, the pedestrians walking on the sidewalk, but it's reckless. There's a chance that you would. So that's how I always think of the difference between intentional and reckless. Physical abuse, what we're looking for critical evidence in order to establish this is we're going to, again, I need to see physical contact, whether it's on a video or witness statements, but that's what we're looking for. We have to make sure that there's actual contact. You're going to get interviews, again, videos if you have them, that speaks to intent or recklessness. That's basically looking at the bigger picture. What was the subject trying to accomplish? Did they act in a way where they intended to do that, or did they just act in a reckless way? Whether there was a physical injury, as I mentioned, or likelihood thereof. If there is no physical injury, so for example, say and you don't, maybe it's a nonverbal person and they can't tell you that they're harmed or express to you that they're upset about something, and they were punched in the face and there's no physical injury. What I'm asking for is maybe talk to somebody, a medical professional or RN, and say, okay, so if someone is punched in the face, but they don't have an injury in this particular situation, what could the likelihood of injury be, or what is the potential harm? And again, impairment of mental or emotional condition or likelihood thereof is, again, talk to other staff members. Our person receiving services was withdrawn after this incident. They went to their room. They didn't come out. These are all really good indicators that something, that it goes to that impairment. Psychological abuse. This one is pretty specific, so we're going to talk about this one. So psychological abuse, it has to be intentional or reckless conduct, similar to the same definition that I just talked about, that causes either an actual substantial diminution supported by a clinical assessment of an individual's emotional, social or behavioral development or condition, or the likelihood of such substantial diminution of an individual's emotional, social, or behavioral development or condition. The conduct can be verbal or nonverbal conduct. So the same definitions for intentional reckless that I just talked about applies here as well. What's interesting, or what is required with the psychological abuse, is that I need a clinical assessment, and it's very specific of who can write this assessment pursuant to our the social services law. It has to be by a physician, psychologist, psychiatric nurse practitioner, licensed clinical or master social worker, or licensed mental health counselor. So one of those individuals needs to give me some type of assessment. It could be verbal or written. And for psychological abuse, excuse me, it has to actually use those words, substantial diminution. That's the key phrase here. That's what is required under our statute. Go to the next slide because I'm going to get into that. So what is substantial diminution? Substantial diminution. It's not the same as the serious or protracted impairment of the physical, mental, or emotional condition that we just talked about with neglect, as well as physical abuse. So what is the difference? Oops, let me go back before I get into that. So as I mentioned earlier, for substantial diminution, it is a term of art. A clinical assessment needs to use that actual term in order for a finding of psychological abuse. However, I had a recent decision come out in 2024, and I thought the administrative law judge, the ALJ, did a really nice job. The decision, the individual receiving services had been evaluated after the incident. I think the staff member was trying to, it was a boundaries case as well as psychological abuse. The staff member was being extremely inappropriate to the person receiving services, conducted them to an unwarranted strip search, and made up some other stories about this person receiving services. After the incident, the staff, the person receiving services was interviewed by a clinician, one of the individuals that I just mentioned that needed to do the assessment. And what they reported was that the individual was like emotionally distraught, just he relapsed too. He also relapsed. So it was all these other things that happened. So while the clinical assessment did not use substantial diminution, our judge actually found that there was a likelihood of psychological abuse, which was really good for the Justice Center, really good for us, because that doesn't mean I can't go after psychological abuse just because it doesn't have that key phrase. Serious or protracted impairment of the physical, mental, emotional condition is different. That's our neglect or physical abuse. So I don't need that language of substantial diminution, but I could use that assessment. So I could use both here. And that's something I want everyone to consider. So just because I don't have that key, phrase doesn't mean we can't proceed. So clinical assessment is key for here. Like I said, it has to be in writing, or it could be in an interview. Please interview the individual on the subject, obtain videos and photographs if they exist. Interview witnesses nearby at the time of the incident. This will help to establish whether the conduct was intentional or reckless. Obtain the plans, such as behavior support plan, behavior charts. That will help to show that because of this incident, the behavior actually changed.
Julie, there's a question. At what point in the investigative process should the psychological assessment be completed?
Ideally, right after the incident. So if you think about it, I mean, I have 2 young children. I don't remember stuff as it goes much past when something happens. So, and I think that's the same for most people. You want to try to talk to them or get them assessed as soon as the incident happens, because that's when it's most fresh in their mind. Obviously, I know that's not always the case, and that's why we're going to get to obstruction a little bit later, because calls come in late and we're not involved too soon. But yes, ideally as soon as possible.
Thank you.
Of course. And let's see. The reason I also put in here, you want to obtain the plan such as behavior support plan, because behavior charts are important, especially for our nonverbal folks. Okay, so just because they can't tell us what's going on doesn't mean that something didn't happen and they're not affected. We have to look at those cues. We have to talk to staff member who actually, are very familiar with them, or even family members, and say, okay, Bobby was fine or did this one day, and then ever since, this bus ride or whatever the incident was, he's changed or she's changed, whatever. And that's important to just document those. And I mentioned the interview witnesses nearby at the time of the incident will help to establish whether the conduct was intentional or reckless. And it's the same as the definition we talked about previously. So obstruction, I'm not sure if everyone knows what obstruction is. Obstruction is the most common one I'm going to talk about, is the failure to report a reportable incident. So as I just mentioned, when someone just asked that question about how soon do I want assessment, we really want, as the Justice Center, we really want a call to come in. We want to be involved as soon as possible because people's memories are they're fresh. When the incident happens, it's fresh in their mind. It's better to talk to them right after the incident occurred. What's required for an obstruction is, under our statute, a mandated reporter is a custodian or a human services professional, but it's not a person receiving services. So typically your DSP or anyone is going to be your mandated reporter. The second element is they have to have discovered that an individual receiving services may have been subjected to a reportable incident. Discovered actually is defined, and we have it on our website just so for folks' awareness. We have a great website with a lot of information, so please check it out. But this is on here. So discovery means when they actually, a person either comes to them and tells them about the incident, they are actually observe it. I had a case where the person said, I'm sorry, I had no idea. I didn't discover this, but we have a video where they're actually looking through the window at someone beating somebody up. I said, oh, okay, then. I'm telling the people's defenses are very crafty. I like it. So discovery, and then a reportable incident. So it's any of those 8 offenses that I touched about in the beginning, as well as a significant incident, which is something that the Justice Center doesn't handle, but usually the state oversight agencies will. And that they fail to report that incident immediately upon discovery. So as I mentioned, discovery is when they're aware of it, they didn't report it, and it says immediately. And according to, as I mentioned, our website, immediately means within 24 hours after notification or discovering it. So that's our requirement under our law. Oops, keep doing the wrong slide, sorry. So the critical evidence for obstruction, I can't even tell you how many times I take this to a hearing and they say, I was never trained. I don't know what the Justice Center is. I don't know the Justice Center Code of Conduct. So I always need training records. We also always need the signed Justice Center Code of Conduct. Is there a policy on mandated reporting? Sometimes I'll even have a picture that the investigator takes of a sign in the office, the Justice Center hotline number. So that's helpful. We also need to know how the subject became aware of the alleged incident. As I mentioned before, that's always something that, well, I shouldn't say always. The majority of time, that's what they said. I didn't know. No one told me. We just had a 3-day hearing about this that ended yesterday, actually, where, she worked in a house that had all these incidents occurring for 6 months, but as a supervisor, she had no idea. So that's our burden. We have to show how they knew. And if no policy or training records, which is going to happen, I would ask that you interview human resources to establish the policy at the facility and whether or not the subject was trained. There are a couple of other forms of obstruction which I don't see as frequently. This one is where a custodian is actually impeding the discovery, reporting, or investigation of a reportable incident. And there's a couple ways that they can impede this. They falsify records, like during the course, say they know that they were sleeping on the shift and then they falsify documentation that says they did the bed checks. So they don't want the investigator to know. So that's one way. They're actively persuading a mandated report from making a report, where they say to a staff member, staff 1 says to staff 2, please don't tell the Justice Center. And then intentionally making a false statement or withholding information, which I have seen that during the course of an investigation where they tell the investigator something completely different. And that the reason they're doing that, and we have to show that they're trying to impede discovery or impede the investigation from moving forward. The last one is something special for a supervisor. So we treat them a little bit differently. They're a supervisor or manager who intentionally fails to act on a report. So that means that they are treated a little bit differently because, like I mentioned on that hearing we just had for 3 days, supervisors should really know what's going on in their house. And when they are aware of a report or an incident, they're supposed to act on it, which means, again, call the Justice Center. So, in summary of what I've just gone through, we talked about 8 possible offenses. The defined requirements, offensive, I've only talked about 4, but there are 8. The defined requirements for those 4 offenses that I talked about today, and the roadmap to determinations, what we're looking for in order to establish each of those elements that I need for all of those offenses.
Hi, Julie. Before we go to break, there's a couple questions.
Okay.
So the substantial diminution, can you just, that was confusing to a couple people.
It's very confusing.
Yeah, touch about
totally
when,
fine.
when that's required versus not required.
Sure. So let's take that one. That one, I completely agree. I think psychological abuse is probably one of the harder offenses. For me, I agree. I think it's difficult. So substantial diminution is required under our statute. It really is just a term of art that's created. What we're looking for when they get an assessment, like when they get a clinical assessment, we're looking for that clinician or whomever's doing the assessment to say that there was a substantial diminution, which means like our service recipient was so affected by the act, by the conduct, in like really, just can't function in an OASIS facility, substance abuse. Maybe they relapse. Okay, that's going to go towards that substantial diminution. It means that it affects their emotional well-being so much. And it, like I said, it's really just a term of art that we're asking the clinician to say, just because, or the clinical assessment, just because the clinical assessment doesn't say that, I've seen cases where we are able to still proceed.
And we're going to cover this a little bit more in detail. And also if, we have the option to, if we still think someone is harmed and there's not substantial diminution, it could be neglect. So it depends on the case. And we're going to cover that later. I think you touched on this, but I just want to emphasize it. If something isn't immediately reported, do we automatically consider that obstruction?
No, that's a great question. I don't know that I actually said that. So while we say immediately within 24 hours, there's always exceptions to every rule, especially in law. So if like you need to call, someone needs to call 911 or they need to get medical emergencies, there are exceptions. We define it generally speaking as within 24 hours. Also, if you know that someone else called in the Justice Center, we no longer make that other person be responsible for obstruction or hold them accountable, I guess, for not reporting if we do know that someone, or they do know that someone else called it in. But generally speaking, immediately is within 24 hours. But as I mentioned, there are exceptions to every rule.
Great. Is staff making false reports to the Justice Center considered obstruction?
Not yet, no. No, it's not. There is there's something in our statute, and I don't know what it is off the top of my head, where if someone makes a false report, it could be considered a crime that the DA's office could pursue. I don't know that I've ever seen that done here since I've been here.
Yeah, generally, I think that's if someone's making a lot of false reports, a provider is an employer and they can make a decision about what to do with staff. There's a couple questions that I think I'm going to answer for you, Julie.
Sure.
Yes, all employees should be signed and trained on the Justice Center Code of Conduct. And on our website, we have lots of resources to help you do that. So please check out our website. What we're talking about today about the offenses, this is for any Justice Center abuse neglect investigation. Even if the provider agency does it, remember the Justice Center reviews all investigations at the end and makes a determination about whether it's substantiated or not. We do have information again on our website about what's required to be reported to the Justice Center for mandated reporters. So we encourage you to take a look at that.
But my name is Mike Marzullo, and I'm joined today by my colleague, Jen McCascio. Jen, do you want to pop on and introduce yourself?
Sure. Hi, I'm Jen McCascio. I'm one of the supervisors here in the State Oversight Agency or SOA Review Team Unit, also called Triage or SOAR. So I've been with the Justice Center for 8 years now, assigned to SOA-led investigations. And prior to coming to the Justice Center, I came with program experience along with 10 years of completing and reviewing investigations. So prior to this, I worked for a voluntary agency certified by OPW or Office of People with Developmental Disabilities. And while there, I worked in vocational services and also worked with transitioning youth and persons with mental health diagnosis as well. So when I started investigations, the Justice Center didn't exist yet. So I've got to experience the changes since the start. And I've been really happy to bring some experience here and share some new information, hopefully with you as well.
Thanks, Jen. Appreciate that. And for myself, I've been an investigator here at the Justice Center since 2014. So Jen and I, for the time that we've been here, very fortunate to, really see things from the beginning and the growth that our agency has had and the communication that we've had with all the providers across the state. But thanks again to all of you for joining us today and staying for part 2 of this session. And thank you as well to Julie for walking through the elements of offenses. As far as what Jen and I do here at the Justice Center and how it fits into this session, our investigators are responsible for reviewing all abuse and neglect investigations that are assigned out to the various state oversight agencies or those cases that are delegated to a provider agency. Once that investigation is complete, the final report and that supporting evidence is submitted to the Justice Center for review, and our team is the first unit to review that investigation. So we're making that initial determination on all recommended unsubstantiated cases for whether we agree with the findings or if additional information is necessary prior to closure. And then all substantiated cases are reviewed and processed by our Office of General Counsel. So when you look at how an investigation can support those elements of offenses and determining that preponderance of evidence, the Justice Center offers what we feel is a valuable resource for provider agencies when an abuse neglect investigation is assigned to an agency or a state oversight agency investigator. But before we jump into what the strategy memo is, just wanted to gauge the level of awareness to the strategy memo. So if you could throw me a thumbs up by hitting that react button, how many of you have heard of or used the strategy memo during an investigation? And if you haven't, since there's no thumbs down button, throw me a heart. All right, well, I'm very happy to see the amount of thumbs up. Makes me very happy. And, given the audience that we have, we expected a little bit of a mixed bag. So we're excited to share this with those of you who weren't previously aware. And for those of you who have used this resource, just made my day. So with that, we'll jump right in. Back in February 2021, the Justice Center implemented the strategy memos to improve the classification and investigation of incidents of abuse and neglect. And really the intention was to create a tool that would be useful for all state oversight agencies and their providers that are responsible for conducting those abuse and neglect investigations. We'll be talking shortly about how to access the memos and what's included on the memos in the next couple of slides. But what makes this resource so helpful is the memos are classification specific, meaning they're based on the initial allegations of abuse and neglect contained in that incident report created by our call center when that initial report is made. So if a case is classified as physical abuse, the memo will be specific to investigating a physical abuse allegation. Regardless of experience or understanding in the investigative process, investigators will be provided this memo to use and follow from the start of their investigation through the submission of that case to the Justice Center. The strategy memos were also created to improve that communication between agencies and the Justice Center by providing some directives for reporting certain information or relevant information back to the Justice Center for review, so we can reassess and determine if potentially a new case needs to be created, just to take a look at that. The strategy memos also outline investigatory questions and relevant evidence to be collected and reviewed. This part really helps ensure that the elements of offenses are outlined in social services law which were covered beautifully earlier in the session and are met prior to submission to the Justice Center. The investigation strategies are meant to provide really just a starting point for the investigation and offer suggestions for other avenues to be explored, including considerations for potentially other abuse and neglect classifications. And we really want to hammer this home. The memos, they're not a catch-all. This tool is simply a guide for investigators, hopefully to potentially spark a new train of thought or to explore different avenues dependent on the information the investigator has available to them. While this resource can be especially helpful for newer investigators, we do recognize that this is not a replacement to the experience and knowledge of an investigator, and that each case that we get is very unique. So we hope this is more of a supplemental guide to the investigator's training and experience. As far as how we access the strategy memos on each case, the memos are sent out with the initial abuse and neglect notification upon case assignment to the Justice Center. So how and where you view the strategy memo is really dependent on your SOA affiliation. So if you're from an OPWDD licensed provider, you would obtain this information from IRMA. For OMH, you're going to find the strategy memo in NIMERS. OCFS IAB and OPWDD OIA investigators are going to find the strategy memo included in those initial BPCR notifications. And they also have access to the BPCR, so you can find it within the BPCR as well. Within the past year, we have made some system enhancements that created hyperlinks to the specific memos right in that initial abuse neglect notification. So basically, it's much easier now to locate the memos within that notification compared to what we had previously. We have met with all of your SOA liaisons to make sure that agencies and that you all have access to view the strategy memo. So if anybody does come across any problems, locating the hyperlinks, please just reach out to your SOA point of contact for assistance on that. So we'll be looking at one of the strategy memos in a minute, but each memo will have the same format with 4 unique sections. The sections include a disclaimer, along with 3 specific sections each time you receive a new abuse and neglect case for investigation. So the disclaimer in section 1, they include directives for reporting back to the Justice Center if certain information is obtained during the investigation. Like we said, it's important that this information is shared with the Justice Center as soon as possible. Great example of this is if an agency becomes aware of an arrest on the case they may be investigating. This information is extremely valuable to pass on for possible reassignment to the Justice Center, where we would get the case assigned to a field investigator potentially. It also initiates contact on our end with local law enforcement and the local district attorney. The disclaimer also states that the strategy memo does not impede investigation into potential related incidents that are uncovered during the investigation, but don't necessarily meet the statutory definitions of abuse and neglect. So if you find a separate mistreatment, during your review, stay right on it. Section 2 is the offense-specific assistance section, which outlines some investigatory questions to be considered during the investigation. This section is specific to the initial classification of abuse and neglect. So we'll see different strategies and questions here between, say, a physical abuse memo and a neglect memo, for example. Section 3 is the evidence to be evaluated section, and that goes into relevant evidence to be collected and reviewed during the investigation. This is also specific to the initial classification of abuse and neglect. And again, this section was created based on some data trends we have observed here at the Justice Center over the years, and the additional evidence that was being requested from providers to further support the recommended determinations. So this section really is intended to help reduce those quality issues following case submission and try to expedite case reviews through a more comprehensive investigation at the front end.
Mike, I have a quick question.
Yes.
Why don't OASAS providers get these memos?
So all OASAS abuse neglect cases are assigned to the Justice Center for investigation. So OASAS does not conduct any abuse neglect investigations.
Thank you, Mike.
You're welcome. I did want to point out that the questions and document types that you'll see within the memos are generic. And knowing that the specific document names can vary between each of the state oversight agencies and even from provider to provider within the same SOA. So we wanted that language to be easily translated across the various providers. But we'll be going through the last two sections in pretty good detail and applying them to an example case shortly. So you'll see some of that generic terminology used. So I'm going to dive into the strategy memo and kind of see what it looks like. And just a heads up here, you may need to copy and paste the link into your browser when you do bring up the memo. We've seen not everybody gets a live hyperlink, so just a quick copy and paste, and you should be good to go. But this is the format that you'll see for all classification types. So try to get the video playing here. There we go. So as you can see, we have the disclaimer. Sorry, 1 second, just trying to get that to play. Perfect. So we have the disclaimer in section 1, which again is the same information on every memo about reporting back to the Justice Center. Then we really get into the meat and potatoes of each memo with sections 2 and 3. Really breaking down the specific evidence or the questions that an investigator may explore based on each of those classifications that you may get. So I know the video played a little fast, but we're going to, really dive in to sections 2 and 3 next here. But before I do turn things over to Jen to go through an example of how, an investigator can utilize the memos throughout their investigation, just want to make sure everybody has a good understanding of where to locate this resource. Because if you can't find it, what good is it? So just want to stop and see if there's any questions about viewing or accessing the memos.
I think the only question I saw was the NYMERS 2.0 from OMH, that there might be some issues.
Okay. Yeah, and that's something we could work with your SOA liaisons to make sure that this is still getting through. But however you receive that initial VPCR notification, where you're getting the incident narrative, you can, it's within that field, essentially.
It would appear that NYMERS is an issue for some people. So you have an assignment, Mike. There you go.
But no, I appreciate that. And Jen, if you want to take it away.
Okay. Well, thank you, Mike. So he just showed you how to access the strategy memo. And now I'll be spending some time showing you how this can be used as a great investigative tool. So we'll be using the strategy memo and applying it to an example psychological abuse case. But before we do that, let's just take another quick look at the elements needed to evaluate psych abuse again. As Julie explained, we're looking to see if was there intentional or reckless conduct by the custodian or subject, whether verbal or nonverbal. And from there, we want to determine if it caused substantial diminution, which would be supported by a clinical assessment. So the clinical assessment is really assessing, again, is there a substantial change in that person's emotional, social, or behavioral development or condition as a result of the incident itself. Or if there is no assessment, then we're also looking at the likelihood of such substantial diminution of a service recipient's emotional, social, or behavioral development or condition. Okay, so we have an example incident here. So according to the incident report, subject Melissa swore and yelled at person receiving services, Suzanne, when she asked to use the bathroom while at day program at 2 p.m. on Monday, November 20th, 2023. This caused person receiving services, Suzanne, to become upset, cry, and engage in a verbal altercation with subject Melissa. So this is where our investigation begins. So now you're assigned to this investigation, and we need to plan out the next steps. So if you guys can type in the chat, based on this allegation, what questions are you going to look to answer during the course of your investigation? So what do you think would need to be addressed to help describe or explain what occurred? I know it's late in the day. Okay, thank you. We have diagnosis, what the patient baseline was, witnesses, cameras. So really we might look to see, for instance, what led up to the incident. Level of supervision, how she was affected, previous supervision. Thank you guys. Was it in there in the VSP? So again, Mike showed you, this is the section of the memo that we're focused on or focusing on right now. And this is section 2, which is the case specific questions. So it's going to give you a starting point to help you begin to ask those questions. It's also going to help you identify any alternative hypothesis. So this section also mentions considerations such as neglect or obstruction, like Julie just explained, that may lead to additional allegations within the scope of this investigation. They may be things that you're ruling out, or they're enough from the beginning to add them as possible offenses. Okay. I'm just trying to look at your guys' answers here. It looks good. I see lots of answers. Thank you. So these are the questions that are outlined on the psych abuse strategy memo. So let's compare that to some of the ones that we had listed. So with our example, we really look at what events led up to this conduct. So this really helps us set the scene. It's going to tell us what happened prior to the subject yelling and swearing at Suzanne. Does Suzanne have any targeted behaviors? If so, was she engaging in any of those targeted behaviors prior to the incident, or was she at baseline? If she was, what does that look like? Just to get a better understanding of her general demeanor. So this may also lead to some alternative hypothesis. So maybe something else had happened with the subject earlier that day, such as being upset or not being able to get coffee. It can explain some dynamics between the staff and the victim. So it's also possible that there's been a pattern of events that had led up to that occurring. So we're also going to look at what the outcome of the subject's conduct was. So was there a lasting or significant negative impact? And we're really exploring what the impact was to that person receiving services. How long was Suzanne upset? Did she need any emotional support immediately after? What did that look like? So these are all helpful when we're evaluating the impact to Suzanne or any person receiving services.
Jen, I just have a really quick question. Do we have any requirements about whether or not statements are handwritten or typed? Do we require people to type their statements?
No, we do offer a provider investigations basics training, and we spend an entire half a day talking about best practices for interviewing. So I would highly recommend that. But oftentimes it's also going to be regulated by the oversight agency itself. But there's nothing as far in our regulations to specify, but we do outline that.
Thank you.
Yep. So when we're looking at case-specific questions, we're also going to look at what trainings or policies were in place to prevent this from occurring. Was the subject aware of how they should interact with persons receiving services? So this is, again, is going to help us determine if those actions of the subject were intentional or reckless. So was there an awareness prior to that incident occurring? So from here, once we start to answer these questions, we'll be able to move forward with conducting the investigation and collecting relevant evidence. So we're going to go back to the example incident. So based on this allegation again, what is some relevant evidence that you guys are going to gather during the course of your investigation? So what would that documentation look like, or who would you interview? Is there any demonstrative or physical evidence that you would to support this? Okay, witnesses, assignment sheets. evidence from any cameras, behavior support plans. So there is so much evidence out there. So what we have done is in section 3, we've listed out some common evidence to be evaluated before a determination can be made based on that specific classification of abuse or neglect. So this really outlines all that possible evidence to ensure a thorough investigation and really support your findings. So our job as an investigator is twofold. Not only are we trying to describe and explain what occurred during the incident, but we're also collecting the evidence to support the recommended determinations for the allegations of abuse and neglect as well. So the purpose of this section is to assist the investigator to have a solid case and really be able to move forward with that case review and case closure faster. So as Mike explained, this list is broad to capture documentation for each SOA, as there are not SOA specific strategy memos. So right now we're just looking at the list for psych abuse, and this list will vary depending on the exact classification. So whether it's a specific type of abuse or neglect, maybe for instance, improper supervision versus medical neglect. Okay, so let's continue with our psych abuse memo. As you can see on the list, there are many examples of evidence that we evaluate and analyze. So we're going to actually break it down in the next slide, but let's compare this to the list that you guys just put in the chat. So it looks like we have quite a variety: job descriptions, schedules, camera footage, which we love, IPOPs, so supervision plans. So we are looking at that testimonial evidence, whether it corroborates or contradicts the report, such as the victim, subject, any direct witnesses, staff observations, any parties that are involved, or professionals. There's going to be a clinical assessment and any subsequent assessments. So we want to make sure that those are signed and dated by a qualified person per the regulation. So it always needs to be completed by either or signed off on by a physician, psychologist, psychiatric nurse practitioner, licensed clinical or master social worker, or licensed mental health counselor. We're looking at documentation of any current mental health diagnosis or conditions, any treatments provided or restrictions. So you guys did a pretty great job there identifying various evidence that we would use to apply that to this. So before we dive in a little bit deeper with a case example, are there any questions out there pertaining to?
There is a question that a couple people continue to have. I think we've answered it, but sometimes people fall off. Should the substantial diminution assessment occur before or after something is substantiated, or should it occur as soon as possible?
So as Julie explains, every evidence in general is time sensitive. So it is still going to take other considerations for the person involved and what's best in their interest and being able to get assessed. Oftentimes it includes gathering specific information regarding that person's, like any behavior changes, any sleep patterns. So we do recommend that it's done as soon as possible, but there's no set time frame. And oftentimes it's also related to when that report comes in.
Right, and there's some other questions too. And each case is going to be specific. Each person might be specific. So we encourage you, if you have questions and you think you want to go down one path, and if the Justice Center is doing the investigation, contact the Justice Center. Or even if we've delegated and you have questions, we're happy to answer questions whenever we can.
Yes, absolutely.
All right. I don't see anything else. I think we're good.
Okay. All right, so we laid out a facts pattern here. So now at this stage, we've used the strategy memo to guide our investigation. We've collected our evidence. So now we're going to review some example case facts and how we just applied it to the allegation before we apply them to the elements of abuse. So here's our facts. So what we found was that Suzanne had to go to the bathroom. She was told by subject Melissa in a loud, aggressive, and demeaning tone that she should have gone earlier. There were multiple staff witnesses, as well as person receiving services, James, who all stated that the subject and the victim had gone back and forth and that the exchange escalated and the victim was crying and shouting. So we know that several staff were interviewed, described Melissa's verbal tone as being stern, aggressive, loud. She was yelling, it was intense, it was high, it was raised. So per that testimonial evidence, we do have that consistency between the victim's report as well as the direct witnesses. We have the clinical assessment that was completed 2 weeks later by the licensed clinical social worker, which found no substantial diminution. So Suzanne did feel that she was yelled at like a child and that staff shouldn't have done that. She feared that the subject would retaliate for reporting what happened, and she didn't want the subject to return. So again, the clinical assessment is assessing the victim to establish if there is substantial decrease in that person's emotional, social, or behavioral development or condition. And as Julie explained, and I just went through too, there's no set time frame. This really does depend on the individual and when the incident was reported. So even if there is not substantial diminution determined by the clinician, this can still be helpful to us when we're evaluating a serious or protracted impairment to the individual, which we're going to discuss again in more detail here in a minute. We're also going to look at the life plan. So what that tells us is that Suzanne is fully dependent on the staff for assistance with toileting due to her disability. There are goals outlined to help her advocate confidently. And she also has a medical monitoring plan that indicates that her target symptoms for major depressive disorder and anxiety include feelings of hopelessness, worthlessness, and increased worry and nervousness. So the plan indicates that the victim relies on the staff for essential functions related to her daily living skills, including toileting, safety, and well-being. She's fully dependent on the subject to assist her with toileting due to her disability. And it also mentions a goal to encourage her to advocate more confidently, as she can struggle with that at times, yet we see her here speaking up. So despite that struggle, we know that this was significant enough for her to self-advocate. And as far as the medical monitoring plan, we're also going to see those diagnoses. And really, this is what's making Suzanne vulnerable here. We know that the symptoms she already experiences include those feelings. And the plan also outlines proactive interventions for staff, so such as providing a safe, supported, structured program environment. Staff should encourage her to express herself. So here we're going to look at what those actions are, what staff are meant to be doing. And we know that those actions of the subject were in direct conflict of those plans. It's not in a therapeutic manner. And then we have the training records. So the training records support that the subject had prior knowledge as to how to properly interact with Suzanne, as well as the vulnerabilities and supports that she needs, as we just outlined. So we're going to use this to support that the subject's conduct was intentional. So there was that conscious decision to act in that manner. Okay. So now that we have gathered all this evidence, we're going to look at the elements of psychological abuse. So now we've done the first part of our investigation, and we've been able to describe and explain exactly what happened and match it up to that allegation. So now we're going to be comparing it to the elements. So we do have evidence to support that the alleged conduct occurred. So now we can move on to assessing the substantial diminution. So in this case, the clinical assessment does not support that Suzanne experienced a substantial diminution of her emotional, social, or behavioral development or condition. So unfortunately, the elements of psychological abuse are not met, which means we would recommend an unsubstantiated finding. However, there are still obvious concerns with the conduct, and we do have that noted impact to Suzanne. So if you recall in section 2, the case-specific investigatory questions, there was mentions of considerations. So here it's going to be specific to neglect. So in the event that the evidence does not meet the elements of psychological abuse, our investigation isn't quite done yet.
Quick question, Jen. Is there a JC assessment form for diminution?
No, but we would definitely have them reach out to their SOA liaisons to see. Some of the SOAs do specify the format or give more best practices related to that.
Thank you.
You're welcome. So when we have a psychological abuse allegation, we do encourage investigators to keep neglect in the back of their minds, especially if there's evidence to support that an incident did occur and the victim experienced some sort of impairment. So we do see these cases quite a bit. So we felt like this would be a great example. We're going to break down the elements that overlap between psychological abuse and neglect. So with psychological abuse, we looked at the intentional or reckless behavior, which involved a degree of awareness. So we can now use that same awareness to also support a duty or the obligation that the staff has to support the individual. So I have another chat question for you guys. I know it's still even later in the day, but from the evidence that we already obtained on that fact pattern, what could potentially support a duty? So how would we know that a duty was established? Or what additional evidence do you guys think would be helpful to determine that? So again, we're trying to look at that obligation or that staff responsibility. Yep, policy, staff training, job description. Okay, everybody's nailing it now. Treatment plan, yes. Signature and plan, also key. Shift sheets, yes. Progress notes, signed code of conduct. All right, you guys, I think, covered a great amount of what we would be looking at. So the breach in that duty is the conduct by the subject. So now we know that this is also our offense. So for this case, it was the staff swearing and yelling at the victim. So we have the duty, which is telling us everything that you guys just listed, how that staff was specifically aware of their obligation. And we already know that we have that breach. So the final component is whether the conduct or that breach led to a serious or protracted, long-lasting impairment to Suzanne's physical, mental, or emotional condition. So we're really looking at was there a high probability that it would have when we're looking at that likelihood. So remember that the evidence to be evaluated will differ based on the classification. So we're going to take a look at the neglect strategy memo. Okay, so we're going to focus on just the elements of neglect that specifically overlap with psych abuse today. Just know that the neglect memos do have much more information. They just don't pertain to these cases, so you want your focus to be on the key points. So for our case example, the only differences that are relevant to this investigation would be the ones that are outlined on this slide. So we're going to look for that explanation of common practice. So this comes up. So here we're really looking at what staff should have done in this situation. It may not be a formal policy or procedure, but it's something that's often recognized by the staff supporting the individual, something that is a common theme or that gets described by staff witnesses. We're going to look at the clinical orders or PTOT guidelines. So these are helpful because they may add to those diagnoses or potential symptoms. They may also already be addressed in those other plans, such as the individual plans, behavior plans, but they can provide some clarification on the assistance that the individual requires by staff as well. Especially in this instance, we're looking at the toileting procedure. And we're going to look at agency policies and procedures pertaining to duty. So again, that's just going to strengthen that duty. It's really identifying the obligation that the subject has to the individual and matching it up to what happened. So we want to ensure that the policies were in place at the time of incident, not part of the corrective actions. And finally, we're looking at the documentation showing that the subject should have been aware of their duty. So it's not just about the policies and procedures existing. It's really key to make sure that the subjects knew them prior to the incident. And you want to find out how the subject knew that they did have that obligation to conduct themselves in that specific manner. If there is a lack of training, you may need to find out why. Was it another staff person's responsibility or a systemic issue? Those might lead you down to alternative hypothesis as well. Okay, so I'm just going to bring up the fact pattern one more time here. We are going to break this down by each section, and we'll be using the same evidence that we collected. So everything that we got on our psych abuse investigation, we are actually applying all of that same evidence. We're just looking at it in a different manner. Okay, so the first piece here we need to identify is the duty. So again, this is that obligation, that responsibility. Let's see if I can. Okay, so for here, it was the code of ethics, our job description, sensitivity training, her medical monitoring plan. So from that, we know that subject Melissa had that duty to support Suzanne with respect and dignity. And according to her life plan, she is fully dependent on staff for assistance due to her disability. So when we're looking at the code of ethics, in this case, it really was showing us that staff's obligation to commit to promoting the emotional, physical, and personal well-being of the people that they support. Signed job description, so again, looking at those essential functions, sensitivity training, and training awareness or acknowledgement of her person-specific plans. And also making sure that they're not part of that retraining. Okay. So next we have our breach in duty. So here again, this is for the neglect portion. We're looking at an action, inaction, or lack of attention. So here we know that subject Melissa breached this duty when she yelled at and engaged in a verbal altercation with Suzanne. And when she requested assistance with going to the bathroom, she was told by subject Melissa in a loud, aggressive, and demeaning tone that she should have gone to the bathroom earlier. And Suzanne also recalled the incident and how she was yelled at like a child and that she deserves respect. So for the breach, we're using the consistency in testimony and clinical assessments that support that the subject yelled at and engaged in a verbal altercation with Suzanne. So the clinical assessment for this case is noted in there that Suzanne recalled the incident and how she was yelled at like a child and deserves that respect. Okay, so next we're going to evaluate what the breach resulted in. So for this case, it was serious emotional impairment. But we need to lay out how we know that there was that connection. So we know that person receiving services, Jim, as well as multiple staff witnesses, were consistent with her testimony and that subject Melissa's actions caused her to cry and shout back at the subject. So subject Melissa's actions caused her to experience that emotional impairment as she became very upset, cried, and shouted at the subject. So as a result of Melissa's behavior, neither persons receiving services wanted to work with the subject and reports that they don't want to see her again. So we also know that it resulted in Suzanne not wanting to work with the subject as she feared the subject would retaliate against her. So we got that information from her clinical assessment. And although Suzanne struggles with advocating competently and is a goal of hers, she advocated for her right to use the bathroom and was approached in an unsupportive and aggressive manner. So the testimony obviously is supporting the impairment that Suzanne experienced. We also have several testimonies supporting that she cried, yelled back at the subject, and that the subject engaged in that verbal altercation, that back and forth, and that she never wanted to see her. And her clinical assessment was also consistent in noting that she also loves day program, but she didn't want to have any contact with the subject in the future, and she feared that the subject would retaliate against her. So even though that would be enough to establish that there was a serious impairment, we also can evaluate the likelihood to result in. So we know that in addition, subject Melissa's actions had the likelihood to cause further emotional impairment, given Suzanne's mental health diagnosis and the symptoms associated with her diagnosis, including feelings of worthlessness, hopelessness, and increased nervousness. So based on this information and how we're evaluating the evidence itself, it would be enough to substantiate neglect, because we have established that duty, that breach, and that it resulted in this serious emotional impairment.
Quick question, Jen.
Yeah, I was gonna say questions.
Yeah, there's a quick one. So I think someone, based on the outcome of neglect described in the clinician assessment, couldn't that be used to support psychological abuse? There's a couple questions about that.
And Julie might want to chime back in here, feel free. Because I think that's the slide that she was explaining the difference between that substantial diminution and the serious or protracted impairment.
I took my, I don't know if you can hear me okay.
Yeah, we can.
So based on this, yes, I think so. And let me just put this back in so you can hear me better. On the case that I did,
Charged psychological abuse and neglect, and we were successful in both. So it was a really good assessment. So yes, I think you can.
And as Julie said at the beginning too, often the same case might have, they might be substantiated for, if they're substantiated for psychological neglect, abuse, you're going to be substantiated for neglect, because that is a breach of, that's not in the person's care plan. It's a neglect of your duty. So it would be both.
Okay. Turn it back over to Mike. Let's take it home here.
Thanks, Jen. As you just saw, the memos can be pretty interactive with working through a case with other classification considerations. But as Jen said, let's bring this baby home by going through some of the overall benefits that we've seen since the strategy memos became available for use. So we've conducted a few trainings with SOA and agency investigators across the state over the past few years, and we've received positive feedback on really the quality of resource this tool provides to those who have used it. Investigators have clear directives for reporting new information back to the Justice Center, which again increases that critical communication needed between our agencies. And investigators, particularly investigators new to the field, they have additional resources for initiating their investigation. And like we've walked through, it includes classification specific questions to explore, which can assist with developing a fact pattern around the incident or an alternative hypotheses, like we saw earlier with the psych abuse to neglect. So when we look at evidence-based determinations, the comprehensive list relevant to the specific offense really assists with satisfying all investigatory questions and identifying evidence to be evaluated in order to make that evidence-based determination. In cases with evidence-based determinations are much less likely to be returned by the Justice Center for additional follow-up or investigation, which leads directly to our next benefit, which is improved cycle time. If we can assist with identifying different avenues or documents to review during the investigation, and that evidence is incorporated into the reports, we're going to increase cases submitted to us with complete information and accurate determinations. And that in turn really improves cycle time with more streamlined review process. And as a result, we can be more timely with our letters of determination to all the appropriate parties. But since investigating the strategy or implementing the strategy memos, we've seen these benefits positively impact the quality of investigation reports and the accuracy of case determinations, all while case cycle time has continued to improve each year. A data point that our agency is focused on over the last 7 years is the percentage of submitted abuse and neglect cases that require additional information from the Justice Center. So if, during review of a case submitted by an agency, our investigator determines additional information or clarification is needed prior to closure, we'll send the case back to the SOA or provider agency. We've seen cases that require additional information from the Justice Center have, on average, a whopping 40-day increase in case cycle time. And because of this, a major goal of the strategy memo is to decrease the percentage of cases that require additional information. So we're looking for that quality at the front end rather than chasing our tail, on the back end. Prior to the strategy memos, we've always fluctuated around 35 to 48% for the percentage of cases sent back for additional information. Since implementing the strategy memos, there has been a 14% decrease in cases that require additional information for follow-up. And that may not sound large, but it equals over 600 cases less per year that are sent back to the providers for additional information, which is a huge win for quality and cycle time. But by limiting the number of cases that require that additional information, it's good for all of us because it decreases, additional work from agencies having to reinvestigate, and it helps us out as well on our review. But most importantly, we're able to provide that closure, to the person receiving services, their families, the custodians involved, because information and evidence is being collected and analyzed and submitted during that initial investigation. Now we'll review the impact of the strategy memos on improvements we've seen from increases in evidence-based determinations. So since 2021, we've had an increase in the total number of confirmed substantiated cases from providers and SOA investigators, totaling about 10%. This increase can be attributed to investigators more consistently including evidence that supports their findings. There's less substantiated cases as well, where the Justice Center disagrees with those findings and the case ends up substantiated. And we've seen a 34% decrease here, which again is quite substantial. It really speaks to the providers and SOA investigators analyzing all relevant evidence. The goal is evidence-based determinations, regardless if the case is substantiated or unsubstantiated. It's easy to think this is only important for substantiated cases. And that absolutely is untrue. We want to support the individuals working in these providers who may not have done what was alleged. So again, major kudos to the providers and the investigators for providing, the evidence necessary to support their findings. Last slide. Even more impressive are the improvements that we've seen in the initial submission of SOA-led cases. So since implementing the strategy memos, SOA-led cases have been submitted by providers and SOA investigators on an average of 65 days, in comparison to 98 days in the 2 years prior to the strategy memo. Even more impressive is the fact that providers were under the statutory requirement of 60 days in 2024, which is amazing to see. This number is so important for the Justice Center review of that case, as we're going to have much more success if we do need to go back with questions a couple months after the incident, as opposed to if the case was closer to a year old. We can also confidently say that the memos provide a certain level of structure to what is needed for that investigation, which naturally can speed up the investigative process. And clearly, we feel this is happening based on the improvements in case cycle time that we've been seeing from agencies. But that includes our portion of the session. Hopefully, at minimum, everyone is, who is an investigator at a provider agency will be on the lookout for the strategy memo. If you are assigned a case to the Justice Center, again, Julie, Jen, and I really appreciate your time this afternoon. It's a pleasure presenting these topics to such a large audience. And I know we're a little tight on time, so would love to give anybody who has a question a chance to put that in the chat.
I think we are pretty good, and it is 3:30. So thank you all. And if you have any remaining questions, contact us and we'll get back to you. Thank you.